On CNN's broadcast Monday night, there was a dire warning. We are entering a constitutional crisis because Trump won't do what federal judges say he has to.
We are 3 weeks into the second Trump presidency, 3 weeks, and tonight there are warnings that the U.S. is dangerously close to a constitutional crisis. A federal judge today said the White House is defying his order to unfreeze billions of dollars in federal aid, marking the first time that we've had a judge expressly accuse the Trump administration of ignoring a court ruling.
Democrat Senator Chris Murphy joined to warn of the end of the country.
This isn't hyperbole to say that we are staring the death of democracy in the eyes right now. The centerpiece of our democracy is that we observe court rulings.
Even though court rulings are inherently undemocratic, actually, at least in this federal context, they come from unelected judges. Now, I'm not saying that's a bad thing. There is good reason. We want these decisions based on law, not based on the passions of the mob. But as though what he's warning about is anything new anyway, because it hasn't just been happening in secret over the last 4 years. It was a campaign point of his party's nominee. Hey, vote for me. I defy court rulings.
Tens of millions of people's debt was literally about to get canceled. But then some of my Republican friends and elected officials and special interests sued us. And the Supreme Court blocked us. But that didn't stop us. No, I mean it sincerely. We continue to find alternatives past the reduced student debt payments.
Did he stutter? Well, Biden does stutter a lot, I guess. But based on the repetition, it is clear he meant exactly what he said.
The Supreme Court blocked me from relieving student debt. But they didn't stop me. And the Supreme Court blocked it. They blocked it. But that didn't stop me.
The Supreme Court of the United States blocked me. But they didn't stop me.
Now, checks and balances are important, of course. If I was serious about concerns with executive overreach under Biden, I should be just as vigilant with Trump. Granted, whether you like a policy outcome does not determine its validity. The process does. But it's also important to be clear and honest about what checks and balances do and about what the nature of this supposed crisis is. The Constitution divides power among the branches. And if one branch tries to steal constitutional power from another, then yes, you have a problem to resolve, often through the courts. In Biden's case, at least the one he was talking about, it was the attempt to steal Congress's power to define and direct the management of the student loan program. He had no authorization by law from Congress to do it, and he had no Article 2 power under the Constitution to do it either. But in these recent Trump cases, we're watching the courts interfere with Article 2 powers themselves, as in the power the Constitution grants to the president as the executive of the administrative agencies. In that branch of government, he's the boss, at least of day-to-day operation. In other words, with these Trump court orders, we don't actually have a dispute between the branches on their constitutional powers. We have the courts just intervening because they don't like how the president is doing his job. Before we get to the reasoning in these court interventions, let's consider the facts. Right now, there are numerous court cases considering Trump's actions on spending and waste and fraud issues, but there are two major injunctions worth highlighting, as in judges' orders for the White House to stop doing something. Margot Cleveland over at The Federalist has done great work providing fast updates on all the filings in not just these two cases, but all the Trump challenges. In Rhode Island on Monday, District Court Judge John McConnell, an Obama appointee, issued an injunction accusing the White House of ignoring a prior order to unfreeze federal spending and ordering them not to do any more pausing, freezing, impeding, blocking, canceling, or terminating of federal financial assistance to the states. Initially, something of a confusing order because Trump had already dropped the effort. Remember, to start the second week of his term, the Office of Management and Budget issued a memo directing federal agencies to temporarily pause federal grant and loan programs pending a comprehensive review to ensure compliance with congressional intent and the president's executive orders. The following Tuesday afternoon, a federal judge temporarily blocked the effort and the OMB rescinded the memo. Okay, so what's the non-compliance that this judge is ordering against then? Well, considering the original memo and the prior court order dealt with grants and loans, the White House only paused their activity in that context. They assumed review of spending otherwise was fine since that's done all the time in every presidency ever. But no, the judge said, you can't pause any federal spending of any kind at all. The order forbids, quote, any federal funding pause. It doesn't matter if the pause is authorized by law. It doesn't matter if the people suing in this case have any connection to that spending or not. They don't. It doesn't matter anything. The president cannot stop federal spending, period, is what the order says. And there are questions about presidential limits in that area, yeah, but there are bigger questions about what authority a court has to make such a sweeping elimination of Article 2 power, to make national executive audit policy unelected on a whim. If we're actually worried about anti-democratic power grabs, well, who elected this guy nobody's ever heard of before is a great question with which to start. And the other case is very similar in that respect. Late Saturday night in New York, District Court Judge Paul Engelmeyer, another Obama pick, issued an injunction prohibiting political appointees from accessing Treasury Department data, as in those other than Treasury Department employees, implicitly including the Treasury Secretary himself, Scott Bessent. This over concern that sensitive personal data would be leaked. So we now have a judge telling the executive which executive employees can access a computer system. There are checks and balances, and then there's micromanagement. As Trump's lawyers wrote in response, such judicial direction of day-to-day executive agency operation has never happened before. Counterexamples welcome, though. Now, of course, there are limits. The president executes the law as Congress passes it. And yes, that includes spending money as Congress appropriates it. And if Congress doesn't like how the president is executing, they can pass new law to direct him otherwise. They can impeach him and remove him if he refuses, or they could potentially act through the courts too. But that gets pretty murky. And why sue if you can just boot the guy out anyway? But is that what's happening here? Congress sticking up for its power against a defiant president? No. Congress and the president largely agree about this issue, actually. The dispute comes from uninvolved third parties with no actual connection to the issue. Both cases are brought by a collection of Democrat state attorneys general who aren't here because they have legitimate jurisdiction in the matter. They do state law enforcement. They're here because they disagree with the politics, even though the politics are for Congress and the president to decide. After the people elect them, they don't have a constitutional stake in the matter, so on what standing are they bringing these lawsuits? Not really specified, actually. Have any of these states actually been denied money owed to them by law? No. Have any of them explained how they will be denied money owed to them by law if Trump continues? No. The supposed harm that establishes their standing is just their hysteria about what might happen, not what actually has. And even if that hysteria is realized, they can still get relief. If it happens, they can sue based on the money that was actually wrongfully denied to them, and then they can collect it. So there is no need for judicial intervention on such a broad scale to correct any legal wrong they may potentially suffer preemptively. Well, if the standing for these lawsuits is sketchy, where did these Democrat AGs find judges even willing to hear their cases? Well, that's the other issue. They went shopping for friendly jurisdictions. Because these claims are so broad and generic, they apply anywhere there's an eager judge. That's why it's Manhattan and Boston and Rhode Island, though in fairness, the D.C. judge on the USAID case is a Trump appointee, but D.C. will get you regardless. In large part, these are activist AGs seeking out activist judges who want a certain outcome. And contrary to all the claims of defending democracy, it's the opposite. It is grasping at straws and it's thrashing desperately precisely because Democrats lost the will of the people in November. Of course, that is not to diminish the importance of the principles at stake here. They are actually crucial to the function of our country. Do we respect the will of the people? Do we respect the constitutional powers of the branches? It's not that these things are unimportant. It's that those warning about what's happening are warping and destroying these things themselves. The people screaming that the sky is falling are simultaneously yanking it down. But that's not to be alarmist either, because to say that Democrats are desperate, they are, implies some futility. There is. Because as much as these principles matter in practical terms, Democrats will not get the outcomes that they want anyway. First, even if they do get their fun with a friendly district court judge, that gets appealed. And these questions are so fundamental to the function of our government, the Supreme Court will probably have its say. And this Supreme Court is not going to enable judicial micromanagement of the presidential domain. Even if they think the president might be acting improperly, they will defer to Congress to clarify. But second, even if all that litigation takes a while and Democrats think they've defeated Trump by delaying him, have they really? Because if they're just going to accuse him of ignoring court orders, and they themselves ignore court orders, why not just ignore the court orders then? What is the judge or the district court going to do about it? NBC's Tuesday morning coverage acknowledged nothing, probably.
They can't ignore them. What happens if they do?
Well, it's an open question how a judge might enforce a contempt order in that case. The judge in Rhode Island basically giving them a warning saying, I meant what I said when I told you to release those federal funds. Please follow my order. But the judge didn't mention what would happen if they don't do it anymore.
Oh, no, not a contempt order. I guess Trump will have to reenact the Fetterman Classic.
Oh, my God, really? Oh, my gosh. It's devastating. Ooh, don't do it. Please don't do it.
So what if Trump is held in contempt of that court? You can't arrest a sitting president. You can't put a sitting president on trial. Only Congress can impeach him and remove him. And then you can deal with that court issue. But Congress isn't going to do that. And all of that on top of the fact that actions within his presidential duties are immune from prosecution, per the Supreme Court last summer. Oh, if you don't do what I say, I'm going to shake my fist at you. That's all the force that these court orders have. And if Biden's frailty was strong enough to withstand that gentle breeze, Trump will be just fine. But more ironic still, despite all of that, the laugh-in-our-faces Fetterman approach is not the route that Trump is taking, actually, despite all the persistent warnings that he's going to seize power and become a dictator. Look, we're watching him dictate it up right now. No, we are not. He's resolving these matters through the legal process, through appeal, through the courts. He's respecting the process and the legitimacy of the court system. It's a point Chris Murphy actually acknowledges once you sit through all the hysteria prior.
So far, they've been talking tough, but I think largely have complied with these court orders.
And once he pursues those appeals and the court sides more with him, or at least undoes the massive scope of these district court orders and scales them back, you can bet that just like overturning Roe v. Wade or upholding gun rights or anything else that cuts against the progressive agenda, suddenly then the court will become a threat to democracy again too. Just like it was last summer when Chris Murphy himself said the Supreme Court is not the centerpiece of our democracy, actually, because it's brazenly corrupt. Well, why is the survival of our democracy dependent on allegiance and obedience to a brazenly corrupt court? If it's corrupt, shouldn't we change it? But if we change it, aren't we defying it? It doesn't make any sense because it doesn't have to. It is just about control, not principle. He wins, you lose, and that's all that matters. It only starts to make sense when you consider the catchphrase as an abbreviation. Threat to democracy is just shorthand for threat to unchecked Democrat Party power, because when even the will of the people is a threat to democracy, there is no other way to understand it. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. It's live on Wednesday and Sunday nights. Looking forward to it. Goodbye.